SJC-13497, Raymond, Frechette, and another, v. Elizabeth DeAndrea and others.
Okay, Attorney Wasser.
May it please the court, Attorney Brian Wasser for the defendant, excuse me, Elizabeth DeAndrea. Your Honors, we're asking the court today to find and rule that it's a deprivation of constitutional due process, equal protection, and Article 11's guarantee of free and unfettered access to our courts for a trial court sitting in a summary process appeal context to fail to apply the indigent court costs law to otherwise unaffordable periodic payments issued under chapter.
Those are payments, right, for, you don't get to live for free, right? The mortgage here was not being paid, correct?
It was being paid up until the mother's demise, and then thereafter,
mother
yes.
paid
correct.
the mortgage, but once your client was living in the house without the mother, there's no payment to the mortgage, right?
That's correct.
So the use and occupancy has a purpose too, which is, there's another party involved. They own the house at this point. I understand it's being challenged, but the use and occupancy is not a fee or a cost. It's to ensure payment. So again, you don't live for free. If someone isn't able to pay those mortgage payments or isn't able to pay rent, they're going to lose the house anyway. They're going to lose their tenancy anyway in many respects. So that's a factor we have to consider, isn't it? That adds rational basis to why you have to pay use and occupancy even if you're indigent, because even if you were not in this lawsuit, you would be paying rent or paying your mortgage.
Well, I think we can't take the prospective effect of what's going to happen in the future.
But that's what use and occupancy is not focused on penalizing the case. It's focused on the fact that somebody is having to pay rent or mortgage, or we can't ignore that. And all your briefing seems to ignore that.
Well, I don't ignore that, Justice Kafka, and I appreciate the question. I don't view use and occupancy, excuse me, I don't view use and occupancy as a penalty in any way. And what you're talking about is kind of like a balancing of interests. And the legislature—
Not a cost, it's got a separate purpose from, a bond or an attorney's fee, or a cost. I just feel like it's lost in the briefing, and it's lost in the briefing that there's another party involved who owns this house that they're not occupying, that's paying taxes. But go ahead, I've cut you off.
So, yeah, ultimately, we have to consider the possibility that they're successful on appeal, and then we see that they're rightfully in possession based on their own fee simple title. I think that this balancing of equities you're referring to is already embodied in the indigent court cost law. The legislator kind of contended with that by saying that if we do waive use and occupancy, or if the Commonwealth pays for it, then under 27E, there's an obligation to repay it. There's a lien on the lawsuit. Ultimately, it's not about how you rationalize what use and occupancy is for. This court's first step—
You concede correctly that it's not strict scrutiny, the constitutional analysis here. It's a rational basis review, right?
No, Your Honor, I would disagree with that. I think it's strict scrutiny.
I thought maybe it's the Amicus briefs that are applying rational basis, certainly. Okay. What's the basis of a strict scrutiny on the constitutional right here?
Well, first stop I would say is what's the Commonwealth's state legitimate interest in providing, post-judgment security?
You're saying we should apply strict scrutiny. Is there a fundamental right
Yes, Your Honor.
It's the fundamental right?
Under Article 11, it's the fundamental right to access the courts freely without having to purchase it. And it's the indigent court costs law is activating those fundamental rights. It's the legislator's expression to activate those fundamental rights.
We've always applied rational basis in that area unless it's a fundamental right that's being litigated over, like incarceration or something. But again, we'll double check the case law. But you got cases that say that we apply strict scrutiny to Article 11 in this kind of context?
I believe it's in the briefing, Your Honor, but I can look up.
Go ahead. I don't mean to distract you. Go ahead.
Okay, Your Honor, thank you. So I think the key point here, so the lower court's decision read Section 5E's plain language as essentially resulting in a conclusion that periodic payments are ultimately exempted from the application of the indigent court costs law. Now, I'm going to do a dive into 5E with you, but before we get into that, I think it's important for this court to understand that even if it agreed with the lower court that the plain language suggested that the indigent court costs law would not apply to periodic payments, that it would still have to ignore it. It wouldn't really matter what the plain language of Section 5E is. And the reason for that is because this court's first loyalty is to the Constitution. So the court has to start with Article 11 as the superior law, the supreme law, and then look down at these other statutes and make sure that they're being interpreted and applied in harmony with Article 11.
And again, that's if we're applying strict scrutiny, right? That's your position, right?
Yes, Your Honor.
What if we don't agree with you and we find that it's actually a rational basis? Do you still prevail?
Yes, the song remains the same, Your Honor. As this court did in the 1971 case of Damascus versus the Board of Appeals, that's on the other side of the spectrum of what we're here today. That had to do with constitutional non-deterrence. In that case, the appellant could well afford to pay the appeal bond, but the plain language of the applicable appeal bond statute resulted in an appeal bond that was so high that the court found that it was unduly deterrent of meritorious appeals.
That's an appeal bond versus use and occupancy, which Justice Kafker pointed out is a completely different purpose, it's completely different.
I agree, but see, from the perspective of a litigant who is scared, struggling to be able to afford to take what they consider to be a meritorious claim appeal, they've got a shot at this appeal being successful. And they're going in afraid that they're not going to be able to afford it. All these costs are being thrown at them. And so from the eyes, constitutional fundamental civil rights is very much a result-oriented game. And so when you put yourself in that person's position, they go into the summary process court, and the court says, well, congratulations, we find that you're subject to the protections under the indigent court costs law, and for a mortgagor or homeowner, waiving the appeal bond is use and occupancy. And so they say, we're going to waive use and occupancy, and then they sort of do this hokey pokey, they turn around and they give some legalese and talk about Section 5E to this poor suspecting homeowner.
We interpret the law, so I don't know, the hokey pokey legalese stuff is kind of why we're here, right?
From the perspective of the party who cannot afford these expenses.
So the litigant is going to have a series of expenses, right? They're going to need to pay use and occupancy, maybe. There's the appeal bond. There's the cost for a deposition. There's
transcripts.
Supplying, transportation to and from the courthouse. There's going to be food for daily consumption. There's all sorts of costs associated with living while you are litigating. I don't see the indigent court costs provisions addressing the regular daily life costs. They're costs of the expenses of the litigation, the expenses that arise from the litigation, not from living. And so I think what Justice Kafker was saying is that use and occupancy is one of those costs of living that really doesn't fall under litigation. And can you just address that? Why is this the same as a deposition expense?
Because when there's a dispute between a mortgagor and a mortgagee, sometimes they need to get on the same page. There needs to be some resolution so that these payments can continue, and they have to come up with whatever the affordable payment's going to be, whatever the agreement's going to be. But they have different claims. One side saying you owe the money, the other side saying you made a mistake, and then a lot of times, unfortunately, the banks ignore these processes, and they didn't have the in-person meeting that were required under FHA. And so during that process, that's where, if the banks really want to protect their interests, they can work with the homeowner, sort out these claims. Otherwise, they do have to be litigated. And under normal circumstances, the homeowner would be making payments as a mortgage, not as use and occupancy. But,
But again, so Judge Winnick, very experienced housing court judge, he wipes out all the litigation costs. He treats your client as indigent. And those costs are assumed by the state. But he treats the use and occupancy, rightfully, at least I think, as different, as Justice Wendell says, a cost of living, which your client hasn't paid for indefinitely, right? You've lost the first case, it's on appeal. No payments have been made for a number, how many years has it been since a payment was made on this house? And somebody else is paying for all of that. They're paying the mortgage, they're paying the taxes. And your indigency is not completely not considered in terms of setting the use and occupancy. It's one of the factors that a judge can consider in the use and occupancy, right?
Yes, Your Honor.
So it's not completely out of consideration, but again, we're focused on the fact that someone's living in this house that's not, at least at the first stage of litigation, the person who rightfully should be there, living for free. This mortgage isn't being paid. There's no rational basis for saying they have to pay use and occupancy if they're indigent. I just don't see that.
It's because, Your Honor, unfortunately, my client doesn't want a free house. She wants to pay, but sometimes you can't negotiate. Sometimes the banks aren't there to work with you and to resolve what the disputes are. But, to dive in to Section 5E, let's look at the plain language, if you will. It's on page 130 of our addendum, if you want to follow along. But I'm going to start reading from where the appeal bond has just been waived.
Counsel, I'm sorry to interrupt you there, but could we just switch back to the indigency court cost statute before? And could I just give you a chance to give your best argument vis-a-vis the statutory language there, why these kinds of payments are, quote, a document, service, or object, which is the phrase that the statute uses not just in 27C, but also 27F and 27G, to talk about the scope of the costs that can be waived or that the state will pay. Those are for documents, services, or objects. So what's your best case for use and occupancy payments falling under that?
Well, it's different depending on whether the litigants are, say, like landlord, tenant, or mortgagee, mortgagor. But to answer your question, Your Honor, this statute is supposed to be liberally construed to effectuate its remedial purpose. And its remedial purpose ultimately traces back to Article 11's guarantee that you'll be able to access and bring meritorious appeals even if you can't afford to pay for it.
Counsel, we're not at liberty to just rewrite the statute. So are you conceding that there isn't really a reading of document, service, or object that includes use and occupancy payments?
Yeah, I believe that that's broadly construed, so I don't know how you would define each and every one of those terms, but, it could fall under service, it could fall under object. I don't know what they mean by object specifically, but I can know from the legislative history that the evil, what they're trying to prevent, is any expense, however we want to label it, from preventing poor litigants or people of modest means from getting all these expenses piled up on them so that they can't access the courts.
But as I look at the indigent court costs law, it doesn't cover, it has the salutary language, like you said, about the not having the doors of the courthouse closed to the poor. But we have lots of cases that look at the text of the statute and say, this is covered, and this, even though you're poor, is not covered. One that comes to mind is post-conviction testing in a criminal context. There's 3 or 4 cases that I know of that say it's not covered by the indigent court costs law, even though your DNA testing probably should be done, but we can't cover it. The statute doesn't allow, and the court has closed the door to the indigent in that circumstance. So when you say it has to be broadly construed to cover all circumstances, I don't know if that's actually true when you look at our cases interpreted in that statute.
Well, I think it's part of the statutory scheme, and we actually can look at Section 5E.
No, I agree with you. We look at the statutory scheme and we look at the words, as Justice Stewart said about, let's look at the words to see what's covered or not covered. That's what we're trying to get you to do, rather than it's an automatic, because it isn't based upon that case law.
Well, The indigent court cost law provides for three remedies: waiver, substitution, which is basically just reducing the cost of something, or payment by the Commonwealth. And I submit that the plain language of Section 5E provides for those reliefs for periodic payments under.
You don't have to pay any use in occupancy, or $1, or $3. I'm just trying to understand where you're going.
No, Your Honor, it's not necessarily. It's just if it's waiver, then no. If
you're indigent, right?
Mm-hmm.
Your view is nothing, right? Zero. I'm just trying to make sure I understand your argument. Any rent is just, any portion of the rent is just, it's going to be a violation of your right to pursue a litigation under Article 11.
rent's a special.
Keeping in mind that Judge Winnick did take a look at the circumstances, right, and looked at what made sense in this situation?
Yes, but I think Judge Winnick misread, with all due respect, the plain language of Section 5E.
But if you'll answer Justice Kafker's question, you're saying that as long as you're indigent, you don't have to pay anything.
Well, indigent is a defined term. It could mean that you can't pay something without depriving yourself of necessities. So you may do, substitution means you're paying something. So it could be that you are paying something. Landlord-tenant's a very different situation in respect to my sister who'll become.
I just want to make sure I get what you're saying. If you're indigent, your view is basically nothing, because you can't pay court costs, which are limited, hundreds of dollars. You're certainly not going to be able to pay rent or mortgage payments. So I just want to make sure we understand your argument. You're basically saying no use in occupancy for someone who's indigent.
So for a tenant, that's not always the case. Sometimes they are continuing to pay rent while they're disputing their lawsuit. But
they're not paying use in occupancy if they're paying the rent.
well, I'm talking about mortgagees, mortgagor now. So yes, in that context, Your Honors, the plain language of Section 5E.
It would be really helpful just to know that, are you arguing that an indigent plaintiff owes no use in occupancy?
In some cases, yes.
In most cases, right?
I don't know the statistics. I don't know that to be true, but
Take it.
if they're indigent, yes.
What's the standard for indigency? How much money is it?
Well, there's different tests for indigency, but the ultimate test is if you can't afford to pay something without depriving yourselves of necessities. So, in other words, the appeal bond itself or the imposition of use and occupancy itself could cause you to become classified as indigent. So, again, Your Honors, if I may.
Yeah. Is it in the brief?
No.
You're about to say?
No, it's just, I just want to go over with the statute language, if I may, with the
Oh,
court.
we've got that, though. Is everybody else set?
Well, I'm just showing where the statute calls for waiver and substitution. It's written right into Section 5.
Thank you so much.
Thank you, Your Honor. It's been both a personal and professional privilege to argue before you today. Thank you.
Okay, Laura Kamara?
Good morning, Your Honors. May it please the Court, Laura Camara for Amicus, South Coastal County's Legal Services and its subsidiary, the Justice Center of Southeast Massachusetts. I'd like to jump right into the bulk of the discussion that this Court was just having. Our position is that use and occupancy in this context is not simply a necessary life expense. The legislature has seen fit in 239(5)(e) to make it a condition on continuing on with an appeal, to pay all or a portion of the rent that is owed. And so that does separate it out from just being a life expense. It is making it a condition of the appeal. And for that reason, as well as the clear language of the indigent court cost law, which includes appeal bonds as
This is not an appeal bond, though. It's different, and it serves a different purpose. It may have an effect on your ability to pursue. But again, they've been found indigent, so no costs are imposed, no things we consider costs. And anything we think, as Justice Winnick said, logically related to costs. So, but can I ask, your view is it's rational basis, right? I read your brief.
Yes, Your Honor.
So the constitutional standard we have to meet is rational basis, not strict scrutiny.
Yes, Your Honor.
Okay, so why is this irrational?
It is irrational because to order someone to pay what they are unable to afford strips them of a right of appeal that the legislature has deemed fit to provide.
The legislature has deemed fit, has said you should pay use and occupancy, or a portion of it, right? They've said the exact opposite. And furthermore, you've got to be able to pay your rent or pay your mortgage anyway. Isn't that something we have to consider here? This mortgage is not being paid, right? Your opponents own this house and are paying taxes but don't have any rights to it. They can't get in it, right? So does that provide for a rational basis for a use and occupancy payment?
Our position is not that you should have to pay nothing. Our position is that the legislature provides that you pay all or a portion. It is our position that that portion, in order to pass rational basis, must be affordable. And that when you read 239(5)(e) with the indigent court costs law, we can satisfy the purposes of the legislature in both acts, that we can ensure that non-frivolous appeals are deterred. In this case, these are appeals that have already been determined to be non-frivolous. And with utilization of the indigent court costs law, we can protect the plaintiff.
How do you, again, in the abstract, again, under Davis and King, you can consider the ability to pay as a factor. But what, if this person is indigent, what are you saying they pay? I'm just trying to understand. You say you can do it, but again, there's a mortgage not being paid and there's rent not being paid. How does this work?
And counsel, could I just bootstrap off of this because I think it's important? Is this a remand case? Because you're saying that they should have to pay something that they can afford, that whatever the use and occupancy payment is, it can't be something that's prohibitive in allowing the defendant in this case to pursue the appeal. Judge Winnick in this case did give a reduced number from what the testimony was to fair market, but there wasn't any specific finding that she could pay this. So is this just a remand case?
Yes, Your Honor, it is a remand, but we would suggest with the directive that use and occupancy must be set at an affordable level, and that the indigent court costs law can be and should be resorted to where that affordable level unreasonably burdens the plaintiffs. The statutory purpose of both acts is to ensure that meritorious appeals go forward, and in the case of 239(5), to present harm.
Rent and mortgage payments are being made consistent with the factors we set out in Davis, right, in King. So, and those factors are not that it all goes away if you're indigent, because that person's would otherwise be making payments, right? They'd be paying their mortgage. They'd be paying rent.
So, Your Honor, if I may just take the time to respond to, I think, what is kind of at the heart of part of your question, that indigency should be assessed, as we present it, should be assessed with the consideration of that payment. So to state it more clearly, when considering your ability to pay, you're looking, pursuant to 227A of the Indigent Court Costs Law, you're looking at your ability to pay for the necessities of life. We are not suggesting that you would not include the use and occupancy as a necessity of life in making that assessment. So, in other words, the court should be looking at, in determining what use and occupancy could be at an affordable level, should be looking at, okay, what other expenses do you have? And what does that leave to pay towards the use and occupancy? And in many cases...
It's almost nothing, right? In your view, it should be 0 to 50 or 0 to... It's not anything to do with the rent or mortgage, right? I just want to make sure I understand what your position is.
So I would, as a legal aid lawyer, speak from my personal experience that my clients, by definition, are indigent.
Right.
Many of them, most of them, pay the vast majority of their rent and are able to pay the vast majority of their rent, despite being indigent.
So then Judge Winnick was correct, right? I'm just trying to understand, if that's the case, he's ordered something that most clients should be able to pay, especially those who own the home, which tend to be at a higher level than the clients you represent.
Judge Winnick could have been correct, but he did not consider first that he must set an affordable level, and that is our position.
How do you know that he didn't consider that?
Based on the decision, it does not appear that he specifically made a finding that he was setting a level that he perceived to be affordable.
So you're saying he has to make findings? I mean, why isn't this an abuse of discretion issue?
It is our position that the level must be set at an amount that is affordable, and that there must be a finding that it is affordable in order to pass rational basis review as applied.
And again, you do this daily in those very busy housing courts where this issue comes up. Well, I take it a fair amount.
Yes.
You're saying they have to make sort of written findings on what?
They must set the use and occupancy with the parameter that it is affordable. And so there needs to be a finding under 27A that the amount they are setting is affordable. And that amount, again, in many cases, is going to be close to the rent, a portion of, not zero. The vast majority of my clients are, as indigent individuals, are able to pay.
But that's what Judge Winnick did, because there was testimony as to what the fair market value of the monthly rent would be. And he didn't order 100% of that dollar. It was some portion thereof, a couple $100 off. So if we even take your personal experience, what is wrong with what the amount that was set here? And why isn't that something that the judge could order for use and occupancy payments pending the appeal?
So the amount in question represented about 60% of the individual's income. Depending on other life expenses, that very well could be too high. But I think what we are focused on is setting a clear standard for judges that it must be affordable, not just a factor, as is currently laid out in King and Comerford, but a controlling factor.
Can I give you a hypothetical? And if we look at this case, and we have the mother who was the original tenant, who had a source of income, and then we have your client, or the client that has some income, and your quibble was with what Judge Winnick did as far as the percentage goes, and the 60%. If the holdover tenant, say the mother passes away, and now we have the holdover tenant, and that person is unfortunate enough to have zero income, right? This is, I guess, at the extremes of this. Would your argument be that a judge could not set any use and occupancy because a person is at the extremes of indigency, even for your clients?
Our position would be that in order to comply with 239.5E to set a portion, the judge should in that instance set a token amount for payment.
Thank you.
Okay. All right.
Thank you.
Okay, Attorney Mitson.
Good morning, Your Honors. My name is Robert Mitson. I represent the appellees. If I may, please congratulate Justice Stewart. Congratulate Maddie. Good luck to both of you. Judge, if I may refer to the appellees as the owners. The property relates to a single-family residence located in Webster, Massachusetts, which my clients obtained by deed in December of 2019. The property was occupied by what I would fairly describe as holdover tenants or tenants at sufferance. I engaged in a summary process that was filed in the Worcester Central Housing Court. After some fairly robust discovery, I moved for summary judgment, which was granted. While that motion was pending, I moved for interim use and occupancy payments. That motion was granted after a very sufficient evidentiary hearing. It included expert testimony, condition of the house, habitability issues, certainly the income of the occupants, which, may I point out, at the time were 4 occupants. That may in part explain the deviation between the interim use and occupancy and the use and occupancy that was ordered post-judgment.
I'm sorry, because some of them had vacated by then?
Yes, Your Honor.
Okay, thank you.
The court has some clear guidelines, and there are 3 sources. One guideline here is Bank of New York Mellon versus King. The other is David versus Comerford, and the other is the clear legislative intent outlined in Chapter 239, Section 5 and 6. The judgment was appealed, as we know. I moved for an appeal bond, and I pointed out to the court that none of the interim use and occupancy payments had been made, not even a penny. I'd also like to impress the court that at no time did the appellant move.
And do we also have in this record, at least the trial record, what the income of the tenant at sufferance was?
Yes, Your Honor.
And what was that in the record?
Well, it was, I believe, Judge, it was $1,100 per month from Social Security. But the court did consider the income of the son, a daughter, and another household occupant.
Oh, so I'm not interested in the mothers. The mothers was $1,100, or the person occupying the house after the mother's death? What is the income of the people living in the house who are not
Yes, sir.
making the
Just as I stated, please.
$1,100 a month?
Yes. And then there were, during the interim use and occupancy, there were 4 occupants, 3 fixed sources of income, and the son was claimed had no income because he was in between jobs, but he was doing odd jobs. So what I wanted to point out is that in exercising his discretion, and I do believe this is an abuse of discretion issue, Judge Winnick considered the household income, habitability, carrying costs such as taxes and insurance.
How do we know that? Because he does a very careful explanation of the statute and why use and occupancy are not costs or fees. But then when he sets the award, we don't have a lot of detail there, right? The plaintiff shall pay the plaintiff $1,275 for the monthly use and occupancy. How do we know he's doing what you're saying here?
Yes, Judge. If we back up a little bit, the Judge Winnick refers to the testimony of the expert witness who opined that the fair market rental value was approximately $1,700. The court pointed to the carrying costs, and he itemized those carrying costs, which included taxes, insurance, and some assessments. So he was quite pointed in his findings of fact, and certainly in the colloquy, not only during the motion for summary judgment, but on the motion of the appellant to waive the use and occupancy. The colloquy was quite detailed, and that transcript will certainly bear that out.
So the fact that he finds that there's $16,500 of unpaid, that's important.
Certainly, Judge, because under Comerford, Comerford allows the use and occupancy calculus to include how long rent has not been paid and the dollar amount of that unpaid rent. So this calculus is just not strictly affordability. That was not the intent of the legislature. It's not, and affordability is certainly a broad policy issue that I think, implicates many, many different discussions, but it's clear what the legislative intent is. If that appeal bond is waived, how are we going to balance the rights of the property owner with the appellant?
Right, I'm just trying to discern, though, so the income, based on his opinion, is $2,100 per month for the two of D'Andrea and Jennifer Wilson together, right?
Yes, sir.
So that the people living in the, and Jennifer Wilson is living in the house as well?
As was the son.
Right, who's not, got no earnings.
At that moment, yes, Judge. He was in between jobs.
They're making $24,000 a year, and he's ordering $1,275 per month of use and occupancy.
Yes, sir. If I may point out, it's not in his finding, but I think it's a fair inference that since his household had not paid rent or mortgages for 10 years, that there was an accumulation of household income. I know that's an inference, but it's certainly a fair one.
The house is, the mortgage hasn't been paid for 10 years at this point?
Yes, sir. So the if I may, the foreclosure actually took place 10 years ago. I think, if you will, a further inference that there was substantial delinquency before that period. So, these occupants have been living for free, literally for free. They paid.
So the non-frivolous nature of the appeal relates to the fact that there wasn't a meeting with the mother 10 years ago? I'm just trying to understand, what was the non-frivolous basis of the appeal that we have here in this record?
It's hard for me to pinpoint. In all deference, we have a pro se litigant, and the cohesiveness of that argument is not clearly stated. But
sophisticated amicus as well. So
indeed, we do. And so, Judge, let us then at least point out what has been articulated, and that is this argument that there has to be a face-to-face meeting between the mortgage holder and the mortgagor.
So 10 years ago, there wasn't such a meeting, and that provides the basis for the appeal that takes us out of the frivolous context. Is that what we're supposed to do?
That's the argument, Judge, although I think that requirement is obviated by the fact that the mortgagor had passed. So I don't see how a face-to-face could take place under those circumstances.
And by the way, I hate to be picky, but I'm just trying to understand, do we have in the record that these plaintiffs are the heirs of, is that in the record that?
Yes, Judge. Interestingly, this appellant filed what we call an informal probate in order to effectuate the transfer of some personal property of the decedent. In that, Judge, you may know that if we have a fairly modest estate, the heirs can file some papers with the court with very, very little cost to transfer assets within a certain range, in this case below $25,000. When the appellant filed those papers in the Worcester County Probate Court, they denied the estate owned any real estate, and this was years past. So it's hard to follow this argument that they have a intestate ownership of this property in Webster when the same appellant denied the estate owned real estate.
We have that again in the record, or are we going outside the record to do that?
Judge, the issue is addressed in the ruling granting my motion for summary judgment.
Is in this record?
Yes, it should be, Judge. If I just may get back, I know the court and my very capable brother and sister counsel are implicating issues of due process and equal protection. I have to strenuously state that those guarantees are more than adequately addressed by the housing court, more than adequately addressed.
Can you be more specific? I mean, I
Sure.
think the argument is that this use and occupancy requirement is prohibiting the pursuit of access to the appellate court.
Yes, Judge. There was, the best person to decide on what UNO should be set at, I believe, would be the trial judge. On 2 occasions, he offered very extensive dialogue and admissions from the appellant as to what could be afforded. And this was, and if I may say, he was very gracious in allowing the pro se litigant to list all of her personal expenses, all of her hardships. Judge, there was never...
But is it your position that this use and occupancy is affordable?
Is affordable?
Affordable.
I think that the use and occupancy complies with Comerford versus Davis because in full regard, because there are a number of factors, not only affordability, that's...
Right, so it seemed like your argument of whether or not it's affordable is neither here nor there. I mean, certainly the judge took account of what the litigant's expenses were and income.
Absolutely.
But the use and occupancy, let's just say for the sake of argument, is not affordable. Is it your position that even though it's not affordable and therefore preventing access to the appellate court, that this is constitutional?
Judge, I think I could address it very simply by answering the question, it is affordable. The occupants...
See, then that falls into the argument that your opposing counsel is making, is that it must be affordable. My question is, even if it isn't affordable, is use and occupancy that is not affordable and therefore precludes access to the appellate court constitutional?
Judge, it is constitutional. This is initially an application of statutory mandate. And when that statute is interpreted by King and Davis, the income of the appellant is only one factor. It's a balancing because we have not just access to justice issues, but we have the property rights of the owner who are sitting on the sidewalk.
And that's actually your argument, right? The argument is that it's rational for the legislature to have said, we can't just consider one side of the V here. We have to consider the affordability, yes, but also the fact that there are property rights at issue that now have come to quote-unquote final judgment, although on appeal. And so we're going to set this rate considering all of these various factors.
Yes, Judge.
Thank you.
Thank you, Joe.
And even to go one step beyond that, not only do we have another side of the V, but we've also had a lot of process here. I mean, I understand that this is on appeal, but we've had a foreclosure process, we've had a summary process. You know, we're looking at sort of appellate rights here, you know, not sort of Matthews versus Eldridge initial stage issues. You know, it's much more complicated from a constitutional perspective than there's no process here, that you're being deprived of process, because you've had a lot of process.
I do agree with you, Your Honor. And thank you all.